Welcome to our June 2023 edition of This Month in Payroll. I'm Claire Soccio, a partner in PwC's Payroll Advisory practice. In this edition of This Month in Payroll, we will explore the Fair Work Commission's annual wage review, recent developments relating to long service leave compliance, and secure job changes that were effective from 6th of June. In early June, the Fair Work Commission delivered its annual wage review announcement, detailing decisions about the National Minimum Wage Order and Modern Award minimum wages. The Commission observed the unusual context of low unemployment, falling real wages, and high inflation, and took into consideration the expected slowdown of economic growth over the next year. It concluded that the national minimum wage will increase from $812.60 to $882.80 per week, or from $21.38 to $23.23 per hour. As part of this order, the Commission has aligned the national minimum wage with the C13 Modern Award classification and increased those rates by 5.75%. This represents an effective minimum wage increase of 8.6% from the previous C14 classification. The new minimum rate of pay is relevant for less than 1% of employees who are not covered by a modern award or enterprise agreement. The Commission also decided that modern award minimum rates of pay will increase by 5.75%, which is expected to impact approximately 20% of employees who are paid in accordance with the minimum wage rates in modern awards. The new rates will apply from the first full pay period on or after 1 July 2023. The Commission recognised that this increase wouldn't maintain the real value of modern award minimum wages, nor reverse the reduction in real value over recent years. It noted a desire, in the medium to long term, that modern award minimum wages maintain their real value and increase in line with the trend rate of national productivity growth. Notably, changes to the Fair Work Act in 2022 now require that, as part of the annual wage review, the Commission considers issues of gender equality and job security. As a result, the Commission has committed to a new research project that aims to identify occupations and industries in which there is potential gender pay inequality and gender undervaluation of work and qualifications, and to consider the subsequent findings of this research in future reviews. What action should employers be taking in response to this year's decision? In addition to updating impacted rates of pay, employers should also consider the impact for annualised wage arrangements or other inclusive rates of pay or set-off clauses. With the national minimum rates increasing by an effective 8.6% and modern award rates by 5.75%, the buffer between the annualised salary or inclusive rate of pay and the minimum award entitlement has been reduced. In response, employers should review these arrangements and conclude whether an adjustment is needed to ensure minimum award obligations are met. Employers should also consider whether this increase impacts the rates payable under an enterprise agreement. For example, if the base rate of pay in the EA now falls below the new base rate for the corresponding classification in the relevant modern award, that higher modern award rate will instead apply to the employee. Finally, when reviewing these arrangements, employers should consider any impact of the superannuation guarantee contribution rate increasing to 11%, which is also effective from 1 July 2023. Now to long service leave, which we have flagged as a growing area of compliance risk for a while now, evidenced by activity emanating out of Victoria in particular. However, it's now becoming a focus of other governments too. The new New South Wales government made an election commitment to create a portable leave entitlement scheme for gig, disability, home care and other precarious workers, so that everyone in these industries accrues annual leave and long service leave entitlements, regardless of whether or not they are classified as employees. We're yet to see details of how the portable leave schemes will work in New South Wales. However, it follows similar commitments made by the federal government and existing portable entitlement schemes for disability workers in Victoria, Queensland and the ACT, and a scheme being developed in South Australia. The second LSL commitment by the New South Wales Government was a renewed focus on LSL compliance. This focus was evident last month when Mosaic Brands, Australia's largest specialty fashion retailer, was hit with a record fine of $29,000 after the New South Wales Employee Relations Inspectorate uncovered systemic long service leave underpayments impacting 220 workers. The fine was issued notwithstanding that the issue was found to have arisen from payroll system errors. The magistrate concluded that the underpayments were not deliberate, and Mosaic Brands fully cooperated with the investigation. In addition, Mosaic Brands has been required to enter into a deed which commits it to engaging an independent third party to conduct a comprehensive audit under the instruction of the New South Wales Government's Inspectorate Unit to assess its ongoing compliance with the state's Long Service Leave Act. As noted by the New South Wales Industrial Relations Minister, Sophie Kotsis, this decision signals a renewed focus on compliance to support a massive expansion of long service leave entitlements to tens of thousands of workers in New South Wales. The New South Wales Treasurer, Daniel Mookie, stated that the ER Inspectorate has a dedicated strategic investigations team, which is currently pursuing a range of large-scale investigations as part of a renewed focus on compliance. Another long service leave case was handed down last month, this one regarding employees who are employed under a pre-modern award, that is, an award that was made before the Fair Work Act commenced, and which gives the employees lesser entitlements than state-based LSL rules. In Conroys Small Goods against Australasian Meat Industry Employees Union, a casual employee, Mr. Finch, claimed he was entitled to long service leave upon termination under the South Australia Long Service Leave Act. However, Conroys Small Goods argued that they had not paid Mr. Finch any long service leave on termination of employment because he had received a loading in lieu of LSL under a pre-modern award. Under that pre-modern award, casuals were not entitled to LSL. The case was initially taken to the South Australian Employment Tribunal, which ruled in favour of Mr. Finch on the basis that the Fair Work Act excludes awards that do not provide an entitlement to long service leave. However, Conroys Small Goods successfully challenged the decision in the full court of the Federal Court. In handing down the majority judgment, Justices Raper and O'Sullivan found that where there are applicable award-derived long service leave terms in a pre-modern award, those terms cannot be overridden by a state or territory law, even if the terms do not provide an employee with a long service leave entitlement. Of note, despite the case focusing on one employer and one particular state's legislation, being South Australia, a number of additional parties joined the proceedings as interveners, including the Wage Inspectorate of Victoria and the New South Wales State Government. The participation of these regulators in other states signals the potential wider implications of this decision, and again, the increased focus by New South Wales on LSL matters. So wrapping up, these cases highlight the heightened interest in LSL, particularly by the New South Wales Government, and serve as a reminder of the need for employers to be proactive in reviewing their LSL compliance and to be prepared to respond to an increased level of queries from regulators. We anticipate LSL to strengthen as a key area of compliance focus and encourage all employers to have this high on their payroll radar. Finally, June 6 marked the start date of the next tranche of secure jobs changes, many of which impact employer bargaining. As a reminder, the changes that came in included simplifying the path to enterprise bargaining, particularly for employees in low-paid industries, franchisees pursuing a single interest enterprise agreement, and employers seeking to form a multi-employer bargaining stream. Simplification of the Better Off Overall test, or BOOT, in that the Fair Work Commission only needs to consider patterns or kinds of work or types of employment that are reasonably foreseeable, not a line-by-line comparison between the proposed agreement and relevant modern award. In addition, the Commission is now required to give primary consideration to common views shared by employee organisations and employers about whether the agreement passes the BOOT. These changes should speed up the approving of enterprise agreements, giving the Fair Work Commission the ability to amend a deal where necessary to address concerns, a move which unfortunately reduces an employer's certainty around their future EA. An EA may be approved, but still remains open to challenge. And employers with pre-2009 zombie agreements must, by now, have notified their employees that the deals will automatically sunset on December 6th, unless an application is made to the Fair Work Commission to extend it. To support employers with the changes to bargaining, the Fair Work Commission has uploaded 4 new videos on its website, accessible via the link on your screen. Other changes, which are not enterprise bargaining related but which are still significant, include flexible work arrangements. Employers are now required to give a written response within 21 days to an employee's request for flexible working arrangements. The changes set out what the employer must include in their response and the circumstances in which they can refuse a request. If the employer and employee are unable to resolve a dispute in the workplace, including through mediation or conciliation, employees now have the ability to take their dispute to the Fair Work Commission. The Commission will assess whether refusals have been made on reasonable business grounds and has the power to order employers to grant requests or to change working arrangements to accommodate, to any extent, the employee's circumstances. The amendments also expand the circumstances in which workers can request flexible work arrangements to include those who are pregnant or where they or a member of their immediate family or household experiences family and domestic violence. And pay secrecy is now outlawed. Workers covered by new or revised employment contracts now have a positive right to disclose or not disclose their pay, and as a result, pay secrecy clauses in new employment contracts, including those made from December 7th, will now attract penalties. Pay secrecy terms in current contracts of employment and written agreements will continue to operate until they are varied or a new contract is entered into, in which case they will no longer have effect. That's it for this month in payroll. If you would like to revisit any of our prior updates, they're available on our website at pwc.com.au/payroll. And if you have any questions or need for support, please reach out to me or your usual PwC contact. Until next time, have a great month in payroll.